can be anywhere and still be available. So I'm going to start here. I think. Can everybody see that?
Give me 1 second. Stop sharing.
Okay.
Yes, I can see it. I'm sorry. You're good.
Everybody should. Okay, great,
Yeah.
great. And it's kind of weird because being virtual, I don't know who's out there. So if you don't mind, I feel like I'm by myself, to be honest with you. If some people can share your cameras, just to let me know that you're there too. Okay. Great, great. All
Give me
right.
1 second, Martin, and I'll unmute their camera so that they can share their camera with you.
Oh,
Okay.
that'll be great. That'll be
No
great. 'Cause
problem. Okay, you should be able to go ahead.
Awesome, awesome. So I know you guys are in your own environment, so that's cool. And I decided to stay here at work today so I could do this presentation because I know what my environment is like home. I have a dog that keeps running in all the time. So I figure I'll stay here and do this. But I appreciate you guys having me today. And we're going to learn a little bit about fair housing as well as tenant rights. Um, Being that, here's my information just so you will have it. Uh, as I stated, I'm HUD certified counselor, fair housing coordinator. I'm here at Greenville County Human Relations Commission, and that's on 301 University Ridge here in Greenville. Um, the things we're going to talk about tonight is know your rights. What we will cover today will be contracts, tenant responsibilities, landlord obligations, reasons for evictions, understand the eviction process, and options once you've been served. Now, all of these things correlate with being a tenant and the rights of a tenant. Knowing this stuff here will only empower you so you can make the right decisions in the event that you're faced with any of these obstacles. So let's just jump into it, okay? And I do ask that you have your questions ready because usually when it comes to questions, when it comes to tenant rights, there's a lot of questions, and I'm hoping that you will have a lot of questions for us tonight. So, contracts. One of the biggest things that I see when it comes to tenant rights and tenants' complaints is that the tenant usually don't read the contract. And that's a major issue because your contract is basically the Bible of your stay at the location that you're in. And what I mean by that, everything you need to know about rules and regulations is in the contract. But if you don't read it, then a lot of times that's what causes the problems of violations or issues that come up, or you don't even know what the responsibility of the landlord is. So when it comes to contracts, and it's pretty simple, the relationship of a landlord and tenant is always based upon a contract, whether it's oral or written, which determines the rights and responsibility of each party that each party has and owes to the other. So there's two types of contracts, and both are just as important, but there's one that is more important than others. Can anyone tell me which one is most important? I like to be interactive, so I hope you guys can do that. So just speak up. I don't have a problem with it.
The written contract.
The written contract. That is awesome. You're right. As it states in the oral, it's illegal, and the contract basically has some of the same things as the written, but an oral contract is no more than a word of mouth. Okay. Now it can be upheld in court of law, but normally a written contract is basically put out. There's no start time and no end time because it's oral. And so therefore it's basically put what they call under a month-to-month lease. And that month-to-month lease means it starts the first of the month, ends the end of the month. And with a 30-day notice, that contract can be terminated. Okay. Now, written contract, I'll just kind of go over the order of contract. Lease terms is usually month to month, must provide contract information such as same as the written of the landlord and the leasing agent. Must follow eviction procedures as well, and should include rent amount, date rent is due, and the right of obligations of the tenant. Now, written contracts are okay, but when you get into a court of law, you're going to find that he said, she said situations to where my landlord told me he was going to do this. Well, is there anything that proves that this is, going to happen? The basic thing of the written contract is basically when what makes that contract binding is when that landlord gives you a place to stay and you pay money and he accepts that money, that binds that contract as an oral contract. Now, a written contract, of course, the agreement is more detailed for court and law. It's executed by a signature on both parties. Not saying both parties have to sign it, but it is written. It says it's executed by both parties, but not always both parties signs it. Lease terms is usually 1 year. Must provide contract information, which is major. You don't know how many times when I ask a tenant, what's the landlord name? And he says, Mr. John or Miss Susie. And I'm like, what's their name? I really don't know their full name because we just basically give them the money. The written contract has that information in there. And the old contract, that information should be provided by the landlord. And like both contracts, they must follow the eviction process, which procedures which we will get into a little later, and must include the rent amount, date the rent is due, and the right of obligations of the tenant. Okay, everybody understand that pretty clearly, right? I'm talking to
Yes.
myself again. Okay.
Yes, sir.
All right. Okay. So let's talk about tenant responsibilities. As you know, when you're basically written, there's two parties. There's the tenant, there's the landlord. Normally there's three parties. There's tenant, landlord, and property manager. So tenant's responsibility, let's talk about that. As you know, the first thing the tenant's responsibility is to pay your rent on time. And I do mean on time, because if you miss 1 day, you usually get a contract that says, hey, your rent is due on the 1st, but you got until the 5th to pay it. If you miss it on the 5th, there is a late fee. If you go further, they can start a terms for evictions. Okay. The other responsibility is keeping your unit clean. Okay. Most people don't realize that's part of the contract. You have to keep your unit clean because the landlord can do inspections. Okay. Keeping the surrounding areas of your unit clean. One of the biggest things I hear on a lot of time where there's trash all around my apartment, but I didn't do it. Okay. But it's your apartment. You need to keep the surrounding areas clean. You also must be responsible for your guests. So you need to make sure you know who's coming into your premises. And once they're in, they're responsible for the contract just like you are, or you're responsible for them to make sure that that contract is upheld, which means if there are situations where they come in and loud noises after the quiet time, or if they actually get mad and punch a hole into the wall, you're responsible for them. Therefore, you can be cited for a violation. Following the rules and regulations of all of the signed lease totally is, of course, and knowing your rights is very important. That's a very important responsibility for your tenant. You don't realize how empowered you are if you know your rights, because not all landlords know your rights, believe it or not. So it's very good to know your rights rather than being there and having to abide by whatever someone says when you know you may have rights. Okay. Landlord obligations. Landlord's obligation is simple: provide a safe and healthy environment for their tenants, respond and make repairs on a timely manner, treat all tenants fairly in respect to Fair Housing Act and the landlord tenant law, maintaining a reasonable, good and safe working order of all appliances supplied and required to be supplied, give proper notice before entering units for repairs and inspections, and provide proper notices of any violations. Okay, this here is pretty deep. Provide safe and healthy environment for the tenants. Most people don't realize that's an obligation, not just to give a person a place to stay, but they have to have a healthy environment for their tenants, which means if you got smoke coming in your vents or whatever, that's not a healthy environment. That's the responsibility or obligation of the landlord to make sure that's not happening. Making repairs on a timely manner. Okay, we see that quite a lot, to where you have landlords that recently, since the pandemic came, everybody wanted to be a landlord. They didn't realize that there were actually responsibilities of a landlord, which means they would buy these properties because other people were selling them because they can't afford it now because they can't work. So therefore they would sell off the properties and everybody jumps in and says, I want to buy this house and become a landlord. But they would let the repairs and stuff go, thinking that, hey, I don't have to fix these things. But a landlord's responsibilities are to make repairs timely. Okay, that is also your right as a tenant to have those things done. When I say timely, when you give them a request, they should make those repairs within 14 days, or give you some sense of time when they're going to make them. But I've seen a lot of times where the landlord just basically sits there and says, hey, you put in a request, and they never reach out to you, the tenant, or anyone to say they're going to make these repairs. Treat all tenants fairly in respect to Fair Housing Act and the landlord tenants law. Well, there are landlord tenant laws and Fair Housing Act that says you cannot be discriminated against because of race, color, religion, sex, national origin, familiar status, or disability. Okay, those 7 characteristics are protected by the Fair Housing Act, and you cannot be discriminated against by a landlord or a apartment complex or whatever, because if you do, those laws are basically held up by the federal government, which is HUD, and can cause a lot of problems for other individuals, such as the landlord. The main reason, the next one is maintain a reasonable and good and safe working order of all appliances. So what that means is, if those appliances and things were there when you got there and rented the place, it is the responsibility of the landlord to make sure they stay working. Now, in the summertime, or I say in the wintertime, there were so many situations to where tenants have been going without heat for months after they put in the repair, and the landlord didn't do anything about it. So it was working before you got there. The landlord's responsibility is to make sure that it's working then. Now, there are essential things that you have to have, and the landlord definitely has to make that work, which is water, electricity, and heat in the wintertime, and sewage. You got to make sure all that is not even negotiable. But when it comes to certain items that has to be maintained, it still falls under the obligation of the landlord. Anything that was there when you started there, whether it's a stove, microwave, or whatever, when you actually rented the place, not stuff that you brought to it, but the appliances that were there when you rented it, that is the obligation of the landlord to make sure it's maintained. One of the other things we find, giving proper notice before entering a unit. okay? It is your right to get a notice, 24-hour notice before that landlord comes into your unit. Normally, the landlord should knock at least 3 times until he hears somebody say come in before he enters. Okay. There's been times where landlords would just come in. The person would be maybe, not clothed, and then they would put in a complaint. But proper notice should be at least 24 hours before they're going to enter your property. Now, in the event that there is an emergency, that doesn't have to happen, because if there's a fire, water, or whatever, there's emergency coming in, they don't have to wait. They don't have to give you a 24-hour notice to come in. Okay. The other thing, far as you have a right as a tenant, you have a right to know if there's a violation. You have the right to know what that violation is. Okay, and that should be put in writing, not saying, okay, you did this or you did that. You need to know what that violation is, and given a certain time according to what the violation is, a certain time to correct that violation. Okay. So normally when you get a violation, sometimes I've seen where they give you a violation and they say, okay, now we're going straight for eviction. Well, you can't do that until you have a chance to cure that violation. Okay. Because it may be something minor. You left maybe trash is out there, and you get a notice of violation there, or they just say we're going to terminate you because of that. Well, they have to give you a chance to clean that up, and then they may give you certain, says, okay, this is the first offense, second offense, but you have the right to have to actually cure a violation. Okay. Reasons for evictions. This is one of the biggest things I see when it comes to problems or instances with landlord and tenants is evictions. There's 3 ways to be evicted, or reasons to be evicted. That's non-payment. It's pretty simple. When the tenant fails or refuses to pay the rent on time, an eviction process can begin. Most leases states that the payment is due on, like I said, on the 1st. It says to the 5th date grace period. And if it's not paid on that 5th date, then they can start the eviction process. The other one is lease violations. That's simple. You did not follow the rules of the lease. Therefore, the landlord basically says, okay, you did not follow the rules of the lease. Therefore, I'm going to evict you. Normally, it's got to be something pretty harsh, or the same violation on multiple times. Okay. And then the other one is lease ended. As I stated, when you get a lease, it has from this date to this date, especially on a year lease. At that end of that date, the tenant decides, hey, I want to stay here longer. Now, there are provisions to let you stay there longer, but you got to let them know. Normally, after a lease termination, and it's a year lease, the landlord will allow to go on what they call a month to month. Although it's somewhat higher, you must still maintain the rules of the previous lease, but you can stay there longer unless there's a 30-day notice saying the landlord that, he wants you to surrender that property. And in the event that you don't, then that becomes a reason for eviction. Okay, is everybody still with me?
Yes, sir.
Yes.
Yes.
Oh, good.
Yes.
Okay, great. All right. So let's start with evictions. Now, I just put this here up. First thing, in order for an eviction to happen, like I said, you had those 3 reasons that an eviction would take place. Now, with that being said, there is a process. Normally, eviction or what they call the process cannot start without a 30-day notice. Now, there are instances where it can, especially where it comes to non-payment. Situations in your lease, like I said, says that you have the first to pay it up until the 5th. After the 5th, you either get a late fee or termination, lease termination or eviction process can start. So what you don't want to do, first thing, you always want to make sure you pay on time. But in the event that a eviction process starts, the landlord has to do certain things. Again, they have to give you a 30-day notice, letting you know that they're terminating your lease. And what most people get confused is the landlord may put crazy stuff on here, like says an eviction notice. Evictions cannot be done by a landlord. Okay? Evictions can only be done by the court system. A lease termination can be done by a landlord or either party, actually. But the landlord, if there's a violation that the landlord wants to get you out, he's going to first give you a 30-day lease termination. And that should be put in a place that you will be able to see, and maybe even send in the mail. But you should be able to have that before any eviction process goes to the legal part first. Okay? And when I come in, I get a lot of times people come in and say, I've got an eviction notice, I got to be out. And I said, no, ma'am, you don't have an eviction notice, you have a lease termination, which means, yes, you need to be out in 30 days, but that is not something that goes on your record as an eviction. Okay? So what happens is the landlord gives you that 30-day notice. You look at the notice, you may not act. Okay? And I would definitely say if you feel like you're in the right, if there's a situation where they're saying you have a violation and you feel like it's totally wrong and you're willing to fight for it, make sure you get in contact with someone when you get that termination. Don't wait until you get a rule to show cause letter from the court. So you get this letter of termination, you don't act on it. You then, 30 days has passed. And remember, evictions are only to get a person out of the property or off of the property. It's not to, come back and forth with the landlord about certain things. They don't hear other cases. The landlord did this, the landlord did that. The case is to basically get you out of the property. Now, you do have the right to discuss the activities that have caused that to happen, and you can defend yourself in the court once you get what they call a rule to show cause letter. And that's the letter you will get if you do not leave within those 30 days. The landlord then will go file for a rule to show cause. And you will be getting that from the court system. It should say summary court or magistrate court, and it's going to have your name versus the landlord name says you've been, they're basically, you've been charged, or let's see, how does it say it? I think it says something like, there's been a complaint that you've been charged with that you did not pay money, or did you not leave the residence, or there has been a violation. Either way, it's going to say that you, it's going to give you notice that it's going to the court system. Now, the major part of this is on that rule to show cause letter, it's going to say, and this is very important, this is where a lot of people mess up. You have 10 days to contact the court and set up a hearing. Okay. Now, guess what usually happens with that? Can anybody tell me what usually happens what cases I end up getting when that happens. Tell me what happens. Anybody know?
People don't fail to adhere to that 10-day period.
You're absolutely right. They will call me, and they've already got what they call the writ of ejection. It says, Mr. Watson, I got this letter here, and they said I got to move out. So I'm asking, I says, well, where's your rule to show cause letter? Well, I got that, and I thought that was fine. I didn't do anything. I said, did you read it? No, I didn't read it. And why you didn't read it? Because on the bottom it says you have 10 days to set up a court. If you fail to do that, it automatically, the landlord can then go for a writ of ejection. Okay, so hopefully no one gets one of those letters, but if you do, please make sure you read it. Please make sure you do the things it says, such as call them and set up a time. Now, if you know you got to move out and you know you're in the wrong or whatever, you know you got to move out, you didn't pay, it says 10 days. Don't call them the first day that you get that letter. Okay, call them about the 8th day. Okay, and it'll tell you what day that you have to call by on there, if I'm correct. Call them about that 8th day, because what happens is it gives you a little bit more time. But if you call them on that first day, that next day they may say, okay, come in tomorrow for your hearing. Okay, I've seen it happen before, and therefore you don't have time to prepare. But if you call them on that 8th day and you feel like you're in the wrong, that gives your lawyer or myself a chance to look over your case and advocate for you if there is a situation to where you are being done unfairly. We need as much time as possible, okay? Then, and once you call them on that 8th day, 9 times out of 10, your court day will be on the following week, which gives you more time. Okay, because that makes sense where if you're saying, okay, I know I'm doing wrong, I got to get out anyway, but I need a little bit more time to pack and everything, that's how you want to do that, okay? So with that being said, but if you fail to do that, the next letter you're going to get is what they call a letter of ejection. Also, before we do that, go back one more. With that letter, the rule to show cause, you can also request a jury trial. Okay, that will give you a little bit more time, but that has to be done right away. Time you get it for the first time you request a jury trial. Okay, that gives you more time, and that gives anybody who's basically going to represent you more time. Okay, say you do go to court and everything is, you still feel like you was in the wrong, but you was treated unfairly. You do have the rights to an appeal. Okay. With an appeal, you would have to go to an appellate court, and they would basically do the appeal, which means you would still have to do the things you're supposed to do, but it will stop all actions of eviction until that appeal is heard. Okay, so make sure you do understand you do have that right too. And these are just little things that most people who end up in court don't know. You do have different avenues that you can take in order to prolong or basically make sure that all evidences are presented on your behalf the way they should be. Okay, not saying that you would always win, but you making sure that everything is being presented that you want presented. But say all that happens and you still get a letter from the judge saying, okay, after you present your hearing, they're still saying, okay, you were in the wrong, you didn't pay, boom, boom. Landlord says, no, I don't want to accept the money now. We just want to go ahead and move forward. Then that's when they would create a letter of ejection, and it will basically tell you when you will have to be out. Now, with that being said, once you get that letter of being out, you want to make sure you understand that you have to be out, because if not, they're going to have a constable there. And the worst thing you can see is all your property on the side of the street, because you did not move it out. They're going to move it out for you. Okay. And then they're going to lock the doors. So you do have enough time to do that. So one thing, is everybody kind of clear on that so far?
Yes.
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 Okay. All right. So let's talk about service attempts. And this is just kind of simple, that they're going to make the person who's basically servicing you these letters going to come at about 3 different times. Okay. With about a minimum of 8 hours between the time they come. They're going to put these letters in a place where you can see them. If they come and says, okay, you have a rule to show cause letter, they're going to put it where you can see it. Sometimes on your door, sometimes they send it in the mail. But it's not going to be from the landlord. It's going to be from the court system, and they're going to have whoever served this letter to you is going to be signed at the bottom. So please make sure. The biggest thing we see is, I never saw the letter. Well, now not only are they putting the letter where they can see it, they're taking a picture of it once they put it there. So you got to make sure, don't play around with the court system. Trust me, you can't win when it comes to that. So we just want to make sure that you understand they're going to be service. These are service agents, which are usually constables, that make sure that you see the letters that you're going to get. Now, one other thing I want you to know, that in South Carolina, evictions, a lot of people don't know this. If it's raining outside, if they're calling for a certain amount of rain in that time, they're not going to evict you. Okay? Or they're not going to put your stuff out. But they will serve you evictions. A lot of times the services here are very sympathetic. Nobody wants somebody to be put out, okay? If you need more time, sometimes you can actually get more time by talking to someone, not necessarily the service person that's coming out to do it, but if you have a good advocate that can help you, they usually can contact the servicer and says, hey, person needs another day or whatever. They do that. But the point is, if you ever service that, don't count on having that opportunity, okay? And we pray that no one ever gets to that point, because it's a sad situation. Now, the other thing is, even after the service process, rent continues to accrue so long as the tenant remains in the possession. Does anybody know what giving up possession truly is?
Turning in the keys.
Turning in the keys
There you
and
go.
moving out.
There you go. Moving all your things out. I've seen people move everything out and say, I'm gone, but they never turn in the key. So therefore, it is not given up. That means the landlord does not have that key at that point and can still charge you. Okay? So it says, even after the service of the process, rent continues to accrue so long as the tenant remains in possession, and the tenant is liable for continual accruing rent. Even if the landlord accepts the rent offer after the service of process, the landlord may still insist to have an ejectment of the tenant, since the rights of the parties at the time of insurance of the rule are controlling, which means even if you pay that landlord part of the money or all of the money at the time that, and you're behind so far, he can still go and have you removed out of that property because you already violated the lease. Okay. And a lot of people think, I'm behind 1 month, and they give them partial payments here. Then the next month comes, And they don't realize now you're behind 2 months. You say, no, I'm gonna pay the whole thing, I'm gonna pay for last month. Yeah, you last month, but now you're still behind 2 months. So it keeps accruing. So it's hard to catch up once you get behind. I just want to let you know that. Okay. This is the writ of ejection, what it looks like. And it's basically Madrid's just going to sign off and tell you exactly what time, when it's going to be that you're going to have to move out. As I talked to you, as I said before, trial for ejection upon a verdict of the landlord, the Madrid should issue a writ of ejection within 5 days. The occupants must move out within 24 hours. That's not always the 24 hours because that is the discretion of the judge. I've seen the judge says, how long do you need to get out? And they said, well, I need a week. And the judge issues them a week. So if you ever get into a situation like that, basically ask the judge, I really need more time or whatever, ask them. And 9 times out of 10, they usually try to look out for that point. Okay. So that kind of ties that up. And I know there's a lot of questions out there because this is a very hot subject when it comes to renting, and I will try to answer them the best of my ability. So can we go ahead and start, Adrian, with the
Yes,
question?
we do have a couple of questions in the chat, and if you want to unmute yourself and ask questions, you can do that also.
Okay.
One question is, do landlords have to give a proper notice of how much they are going to raise your rent?
Yes, they do. That should be a 30-day notice. If there's going to be a rent increase, any changes in your lease, there should be a 30-day notice about the raising of rent. But if you have a 1-year lease, they cannot raise your rent until that lease has expired. Now, if you're on a month-to-month, it can. But a 1-year lease, you cannot, if you're saying, hey, I'm going to rent this place for $2,000 or $1,500 until December the 31st, that landlord cannot come back and says, okay, we're going to rent that, we're going to change that to $1,800 now and not $1,500. Cannot do that until that lease has expired.
Whom should a person contact if a person is having difficulties getting repairs completed?
First thing, anytime you have a repairs, the first thing you need to do is what we call a 14-day letter. That letter has 2 types you can use. It's called a 14-day letter with the intent of terminating my lease, or the 14-day letter with the intent of seeking legal actions. Now, before you do that, you would need to fill out the 14-day letter, state everything that needs to be repaired in that letter. You would then take it to, after you fill it, well, you got to choose which one you want to do. Are you willing to leave the premises and not be charged early termination fee and receive your deposit back? That's the letter that says I'm going to terminate my lease if you don't fix this. Okay. Or are you going to get legal advice or legal help? So what you do, you write the letter, everything in it. You then send that letter. You make sure you put your intent in there also, what you're going to do. Then you send that letter to the landlord, certified. Okay. I know a lot of people say, well, I sent a text message or I told them about it. You know, they still haven't done it. But the 14-day letter is necessary to start the process when it comes to getting something repaired legally. Okay. So what you do after you send it certified, once it's delivered, you're going to receive a green receipt postcard saying it was delivered. And then you start counting the 14-day letter, 40 days. After those 14 days, if that landlord has not made an attempt to repair that, okay, then you can either, I know here we actually use code enforcement. code enforcement usually go out there if it's major issues, and they can actually have fines on that person, put fines especially if it's a water situation. But after those 14-day letter, after it's 14 days have passed, then you have the right to terminate your lease. Or see, because you gave them due notice, but 14 days is the proper. To answer your question, if you have someone to call now, I'm not sure if your office there, Adrian, that helps with that situation, but we get calls all over the state. Trust me, you could always call us if you don't know. We get calls all over the state. We even get calls out of state sometimes. So we'll be glad to help you, and I know your agencies would be the same thing.
I have a question. So when you say the 14-day letter, is that 14-day letter, is that instituted after the original request, or are you saying that the 14-day letter is something a tenant would use as the first step of communication?
Well, I think the first step of communication would be just that, communicating. We find that a lot of times the biggest problem with the situations are that there are no communications. Okay. I think you have to put in your request. I think they have a lot of times a repair request that you put in. Okay. But if you never put that request in and you send them a 14-day letter, then how do they know that something is wrong? 14-day letter is basically used when that landlord has knowingly has the problem and refused to fix it. Okay. Or like I said, has not fixed it in a timely manner. But the first step would be making sure the landlord knows there's a problem, and that's by putting in a repair request. Did that answer your question? Please be
Yes,
careful
sir. I
while
was
you're driving.
just trying to get clarity.
Yeah,
Yes,
please
sir.
be careful while you're driving, ma'am. I don't want that on my conscience.
No, I'm actually pulling in now. Thank you.
Oh, thank you. I can't explain that one.
Andy, you can go ahead and unmute yourself and ask your question.
Hey, thanks for your time. My question is, what's a reasonable time to get appliances fixed, like air conditioning in the summer, something like that?
Well, in the summertime, it should be fixed as soon as possible, because especially when temperatures has reached over 80 degrees, the air conditioner should be fixed as soon as possible. And that can be done, especially in the event that you may have someone elderly or sick in the house. Now, that can be done normally by phone call if that landlord has not fixed the unit or whatever. I've been known to make phone calls to the landlord and says, okay, right now you are responsible for making sure that this unit is fixed, and you need to make a motion. You need to make motion to get it done, because it's 80 something degrees out there and it was supposed to be running. I would say, when you say a reasonable time, a lot of times you're looking at, if the landlord is being constantly transparent with you, saying, okay, I'm going to do this. I'm having problems get this thing. What other options does he have? I've seen landlords bring in portable air conditioning units until they can get certain things fixed. But I would say that when you say reasonable time, I would say constant communication would be the best thing, so you will know exactly when to expect it. Now, if he's just brushing you off after you've asked for it, put in that letter, okay? Put in the letter. Okay?
All right, thank you very much. I appreciate it.
Excuse me?
Thank you very much. Appreciate your time.
Okay.
There's a couple more questions. I see a lot of hands up. We're gonna try to get through them. We got about 5 more minutes. Do landlords have to give a proper notice of how much they are going to raise your rent? I think I asked that one.
Yes, but they do have to give you a proper notice of 30 days. But if you're, like I said, under contract, they cannot raise your rent at that time. And they cannot all of a sudden, they have to give you a 30-day notice to let you know that they're going to raise the rent. And like I said, with every contract, you need to know the contract, the landlord's name, the date your rent is due, and how much you need to be paying. So they have to let you know. Now, the only problem in South Carolina, most people don't realize, there is no ceiling for how much they can raise the rent, unless you're a HUD agency, or to where they can only raise it so much at a time.
Are landlords required to offer a grace period?
Are they required?
Yes.
Far as normally, yes. Every contract I've seen has been a grace period. Now, they're not required because, like I said, there's oral contracts, but that's not a great contract. If it says it's due on the first, I've seen contract that says they're due on the first, and after the first, we're going to charge you $50 late fee because, but I've seen situations where they're not actually any grace periods there. Contracts are really strange because mostly they're made up by the landlord. And always remember, a contract is not for your benefit. Only benefit it helps you is to make sure that you still have a place at a certain time, but it's designed for the aid of for the landlord.
This one's a long one. I've had a leaking bathroom sink with request to fix since November of last year. Just had a contractor come look at it at the beginning of last month, telling me I need a new sink. No notice he was coming over. I'm still waiting for a new sink or news on when it will be worked on mid-April. Same with mold spots coming through the ceiling in the bedroom and living room. Nothing fixed. Rusting, dirty, HVAC vents also. I've never had a notice of worker coming in to look at my work order request either. What are just causes for a tenant to break a lease and move to another living situation? And does the tenant have to give the landlord or property manager notice? If so, how much and what would that process look like?
That would be the 14-day letter, as we stated. 14-day letter with the intent to terminate your lease. Once you do that, then you can move forward, but you must give them the 14-day letter, letting them know that what your intentions are and that they go through the whole process. Once you do that, then that is a process that you're asking about right there.
Okay.
Can a 14 letter be an email as well?
I would suggest the 14-day letter be a certified letter, because even though emails are digital, now the request can be, now the request you asking, can the request be email or the 14-day letter?
14-day letter.
I would suggest the 14-day letter be certified.
Well, that's 15 minutes.
Thank you.
Okay.
Someone wants
And
to
that's
know
only because digital things can be modified or whatever, but once you actually send a letter and it's signed and all that, it holds up better in court.
how come it is harder to remove a squatter versus a renter?
How comes it's harder to remove a squatter versus a renter? Okay, now when you say that, I guess I would have to have the whole gamut, the situation, because that's a pretty hard question to answer when you say a squatter, because 9 times out of 10, if a person just goes and takes over your land, you have police that can get involved, versus if you have a renter, you have to go through the process. When you say squatter, does that mean you have an open property that somebody just came and moved in, and I would have to have more. I would have to have more information on that. Sorry.
And some of the participants wants to know, can we share your contact information with them?
You most certainly can.
Can a landlord ask a tenant to leave anytime if they are a month to month without a cause? Is a 90-day notice valid?
A 90-day notice valid? It's actually more than what's required on a 30-day lease, on a month-to-month lease, if that's what you're asking. 90 days, that's 3 months. And like I said, if you're on a month-to-month, your lease starts on the 1st and ends on the 30th or 31st, and then starts over again. Anytime between that time, after that 30th day, you have to receive a 30-day notice saying that they're not going to renew. Therefore, that's when you have to make arrangements to leave.
Is
But
there a
90 days is actually a lot.
Is there a website tenants can have to be educated on their rights? I'm sure you have probably heard about the incident at the Colonial Apartments in Columbia, South Carolina during late December.
Okay, and I want to say probably not, because I'm in Greenville and I haven't heard about a lot of things in Columbia. But far as just educating yourself on information with rights, you can go to HUD.gov. But I'll be glad to help you. If you'd like to give me a call, I'd be glad to talk further with you, and possibly get you some resources. But like I said, I'm in Greenville. I don't know too much about what goes on in Columbia, but I'm pretty sure everything that goes on in Columbia goes on here.
Kimbrella, you can go ahead and unmute yourself and ask your question.
Thank you so much for this wonderful presentation. I had a question. If a landlord decides to not renew someone's lease, are they supposed to give a reason if that tenant has never been late, never received any notice of violation?
It would be good if they did. If they're on a 30-day notice, in your contract, a lot of times the 30 notice says a person can, they can actually terminate the lease at any time for any reason. Okay. Now we do find that can be sometimes we look at it more closely. If a person is just terminating that lease, maybe that person has, sometimes the landlord terminates and don't want to tell the person because we found out that they're getting ready to sell the property or move their relatives in, but they can still do that. But now if there's a situation, just to say that they can terminate on a 30-day lease, they can do that. You can terminate it for any reason. Now, if you feel like it's a discriminatory situation, that could be something you can look at it. But again, that would have to be more information. I would have to see exactly why. But just to say, hey, we're not going to renew your lease for the next time, and if it's on the 30 days, they can do it.
Thank you so much.
And George, we're going to take you can unmute yourself and you'll be the last question for tonight. Okay. All right.